grounds 1 and 2. I've got one ground left, ground 5, PSED. What I'm going to do is to refer you to 4 cases. I've got limited time, so in essence I'm going just to refer you to the relevant passages so that you've got them. And I'm going to make some very brief submissions on how respondent puts ground 5.
Yeah.
First case, Holmes Morehouse, a well-known case. It's in the original authorities, tab 13, page 70. The issue was that a family court made a shared residence order, but the father applied as homeless. The local authority decided that the children not reasonably expected to reside with the father applicant. Page 79, within the judgment, leading judgment of Lord Hoffman, paragraphs 25 and 26, simply material to what Lord Neuberger later said. So one sees at paragraph 25 the way the reviewing officer dealt with a representation that had been made on behalf of the applicant. You submit the children should be considered to reside with both parents, and as such your client should be in priority need. And then went on to say, it seems to me that something more than the fact of staying is required before one would ordinarily describe the children as residing with the homeless parent. I'm satisfied the children do not reside with Mr. Holmes Morehouse, and neither are they expected to reside with. On the face of it, complete nonsense. And the Court of Appeal, indeed, as your ladyship see from paragraph 20c, the Court of Appeal decided that was a misdirection, because if the court order had been implemented, the children would have resided with both parents. So Lord Hoffman says it basically accepts the error, but it's irrelevant. And that provided the context for the well-known guidance, pages 85 and 86. And if you've done any homelessness cases, you're probably fairly familiar with paragraphs 46, culminating really paragraph 50, a benevolent approach to be adopted to the interpretation of review decisions. Not take a technical view of the language, search for inconsistencies, or adopt a nitpicking approach. The court should be realistic and practical in its approach to the interpretation of review decisions. In some ways, that meshes with my submissions under ground 2. Then he went on, further, as the present case shows, a decision can often survive despite the existence of an error in the reasoning advanced to support it. He gives some examples. The error is irrelevant to the outcome, trivial. Sometimes it's obvious from the rest of the reasoning read as a whole. The decision would have been the same, notwithstanding the error. In all such cases, the error should not, save perhaps in wholly exceptional circumstances, justify the decision being quashed. And so that's why the approach of the court when reviewing an administrative decision, but especially a homelessness review decision, really is strongly encouraged to look at the substance of the matter. It's not about the words. It doesn't even matter if a particular phrase is wrong. If I had £1 for every administrative decision I'd seen that expresses conclusions in over-emphatic language, classic being there's no evidence of this, when what they really mean is the evidence does not prove this. So one shouldn't, that chimes with basic principle, one's not subjecting it to a kind of detailed linguistic analysis as one might do with the decision of a judge. One can't expect review officers to express themselves with judicial precision and temperance, really. So that's Holmes Morehouse. The next one is Hotak, which is the next. No, it's not quite the next. It's at page 102, tab 15. You may be familiar with this case. It was the Supreme Court overturning the Pereira test for vulnerability on the basis that the Pereira test suggested the wrong comparator. Comparison being more vulnerable than an ordinary street homeless person as opposed to more vulnerable than an ordinary person. But the part we're interested in, paragraphs 78 to 79, page 133. So this is under the heading, Lord Newberg is considering the Equality Act 2010. That begins at the bottom, page 131. What I'm particularly interested in is paragraphs 78 to 79. Do you want an opportunity to read those?
Yes, sorry, read those. Yes.
So this is really the source of the focus very sharply requirement. Note that paragraph 79, Lord Newberg is saying that it's not about whether actually the decision maker knows about the duty. It's about whether they conscientiously focus on the relevant matters relating to disability. And the final sentence of paragraph 79 is, as it were, qualifying the Holmes-Morehouse approach. But one might ask, by how much? But we do see on the facts of HOTAC, there were actually three cases, Carnu, Johnson and HOTAC. So Lord Newberger went on to apply principles he just set out to the cases. So page 134, paragraph 81, Carnu's appeal was allowed on the basis that it assessed Mr. Carnu's vulnerability by reference to another ordinary street homeless person. And that's the wrong comparator point, which the Supreme Court held was wrong. But it's notable that Lord Newberger went on, it is plain that an appeal against a review cannot succeed in every case where the wrong comparator has been invoked or a wrong legal assumption is made. Indeed, I do not think that Mr. Carnu's appeal could succeed if the only error was the reference to street homeless. In this case, the important factor to my mind is that Mr. Carnu had and has what appears to be a pretty strong case for claiming to be vulnerable. It's therefore quite conceivable that the review would have gone the other way if the right comparator had been used. So it doesn't look enormously different from the approach under Holmes-Morehouse, notwithstanding the qualification at the end of paragraph 79. And indeed, if one reads paragraph 82, Lord Newberger actually says PSED, it doesn't make any difference on that facts of that case. I would not, however, have allowed this appeal based on the equality duty. While some might find the outcome of the review surprising, in my view, albeit in a rather prolix and slightly confusing way, Mr. Manuel did approach the question of Mr. Carnu's vulnerability in a sufficiently full and considered way to satisfy the equality duty. The letter appears to identify each aspect of his disability, to address with care the questions of how they would be dealt with if he was homeless, how they would affect him if he was homeless, whether he would therefore be vulnerable, and why, in Mr. Vanuel's view, he would not. And didn't place much reliance on the fact that specifically mentioned, which, yes, possibly influenced my approach earlier on. But it's interesting that it's instructive that the PSED, you can apply the wrong test, but the review also applied the wrong test, but focused closely on the applicant's disability, no breach of the PSED. It's an important conceptual distinction between what the PSED requires and what substantive law requires. And we then see, in terms of Mr. Johnson over the page, what happened. Wrong comparator again. Relied on statistical evidence. So you may know, or I can tell you, there was statistical evidence as to how unwell street homeless people were. And that was relied on, in particular by the interveners, for whom I had the privilege of acting. That was a shelter and crisis, to say, well, if you apply this test, no one's ever vulnerable. And that was the approach at that time. They would compare the vulnerability to statistical evidence about street homeless people. But nevertheless, Lord Newberger upheld that decision. It's a clear example of a review whose conclusion is not impeached by the fact that the proper comparator was not invoked. And then paragraph 85, that's going on about the heroin problems. Towards the end of paragraph 85, it's fair to say that the passage dealing with Mr. Johnson's drugs problem is not conspicuous for its clarity, but that appears to be its effect. So, again, one sees the approach being applied, that it's not a nitpicking approach, it's very much a substantive approach, and to try and gain a sense of what the overall thrust of the decision is. Next case, after Hotak, is Poshtek. That's divider 16, page 140. This was a suitability case that might have some echoes with the present case. The allegation being that the homeless applicant suffered from PTSD, had been imprisoned and tortured, and the accommodation, when she saw it, reminded her of prison and caused her to have panic attacks and so forth. It would have made her unwell had she accepted the offer. That was the case. And at page 160, yeah, so you can see that at page 151, you can see the facts are at paragraph 9. There's medical evidence from a clinical therapist. In my opinion, the effect of being housed, this is letter E on page 151, the effect of being housed in accommodation with very small dark rooms without windows and a normal height would inevitably remind her both the cell she was confined in and so forth. She might suffer a serious relapse and not be able to look after her son safely. And then the reviewing officer's decision is set out with paragraphs 11 and 12. So rather like this case, one sees paragraph 11, the reviewing officer specifically addressed mental illness, considered whether this offer of accommodation was reasonable to you to accept it, given your history of imprisonment and ill treatment in Iran, and your PTSD, etc., anxiety and depression. And then the passage in the decision it was criticised, page 153 at the top. So that passage was criticised as applying the wrong test. And what Lord Carnwath, giving the leading judgment, made of that is at page 162 to 163, paragraphs 38 to 41. And it's really paragraph 39 that I rely on. But, I mean, all of paragraphs 38 to 41, but 39 is the key one. And then over the page.
Should we read paragraph 39?
Would you like to do that now? Yes, please. I detect that your lordship skipped ahead over the page.
I'm only going there now. Where should I begin?
Paragraph 40, the review decision didn't mention the panic attack, although that had been alleged in correspondence, and that wasn't an error, notwithstanding the PSED. And then paragraph 41 over the page, paragraph 45 we looked at could have been better expressed. Read in the context of the preceding paragraphs, the tenor is reasonably clear. Medical evidence was based on a false premise. The assertions she'd apparently made to them about the physical features of the property did not match the facts. So, again, it really, if one asks, well, how much difference has the PSED made? One might think, reading this Supreme Court judgment, not a huge amount different. Certainly what it doesn't mean is that one should become linguistically over pernickety. What Lord Calm was referring to is the tenor or the thrust of the decision. And that's the same when the PSED is applicable, as it obviously was in that case. And the last case I wish to refer you to is McMahon, which is tab 21, begins page 243, judgment of the Court of Appeal, leading judgment, Lord Justice Lewison. The point I'm particularly interested in is quite a detailed analysis of all the previous cases on the PSED and reasons in homelessness decisions, which culminates in paragraphs 67 and 68 on page 260. I think I just sit down. I will have about 3 minutes to address you on the back.
Good.
So the overarching submission I make is that on a fair reading of the review decision, Mr. Perdius clearly did focus sharply on the mental health problems that Mr. Bussandra suffered on their relevant effects in terms of his decision making, in terms of the reasonableness of continuing to occupy the accommodation. And moreover, the way that the case is put, or has been put, is really to treat the formulation of the PSED in the case law as almost as an incantation. That's all the respondent has ever done in these proceedings, is to just recite what the PSED requires, never to say how Mr. Perdius failed to comply with that. What we now have in the respondent's latest skeleton argument, paragraphs 20 to 21, so page 220 in the core bundle. Two points.
Sorry. So we can put the bundle of authorities away.
We can.
But we need the latest skeleton.
Yes.
Yep.
I imagine your lordship, in accordance with his usual practice, has vandalised that.
I have. Yes. But I have it here.
So paragraphs 20 and 21. So these are the submissions as to how Mr. Perdius failed to comply with PSED. The first is, this is because it focused only on one aspect of the possible effect of his mental health problems, namely whether he was unable to rationalise and think clearly. That is ground one. Got nothing to do with the PSED. As I showed you in Carnu, the reviewing officer applied the wrong test. Lord Newberger, for the majority of the Supreme Court at least, I think probably all of them on that, I can't remember. But yes, all of them on that point, said that didn't mean the PSED wasn't complied with. This is a misdirection point, not a PSED point. Let's assume that Mr. Perdius did apply too narrow a test. Well, in my submission, he did so, focusing sharply on the medical evidence, the disability, and the effect, applying the too narrow a test. So there's no PSED point in there. And then paragraph 21, really that's ground two. It's saying that Ms. Pisanesky's opinion was not properly addressed. Well, that's just the rationality point all over again in my submission. The respondent may not like Mr. Perdius's assessment of that medical opinion, but it's clear that he closely focused on it in terms and rejected it. That's not a failure to have a sharp focus. So my submission is that the submissions purportedly in relation to the PSED do not actually add anything to the other grounds. And I've gone over by 4 minutes, for which I apologise profusely to my learned friend Davis, King's Counsel.
Thank you very much. Miss Davis.
Excuse me. My lords and my lady, thank you. Thank you, Mr. Hutchins. Following Mr. Hutchins, a roadmap, a few preliminary remarks. I will then address Mr. Hutchins' submissions on deliberate and therefore what could be non-deliberate. And then I will go through the three grounds before you. Ground three, you will have seen from our original skeleton argument, we don't oppose, we accept that the learned judge took some irrelevant matters into account. We say that doesn't matter for the purposes of the appeal. Yourself should not quash the learned judge's judgment on that basis, that the final conclusion of the learned judge, which is that the review decision should be quashed and the local authority required to retake it, stands on the basis of what were grounds 1, 2 and 5 before him, and are now grounds 1, 2 and 4 before you.
Ms Davis, just before you go any further, I'm terribly sorry, but I don't think I've got your supplementary skeleton argument. It gets read as one
I do
page.
apologise, it should have been in the bundle, but I have a copy.
I apologise for the.
Well, my name is probably if the fault's anywhere beyond our side, because we updated the core bundle and your ladyship appears not to have it.
Yeah, it's not in mine.
And then therefore your ladyship has our supplementary stuff that we've not agreed. You have the earlier core bundle.
Right.
Yep.
Anything else that would be missing?
I don't know, we only added your skeleton and not agreed off.
To check.
I'm so sorry,
So
my
I
lady.
may have
To
the
check
wrong
that.
bundle altogether.
You've got the wrong bundle, but the only differences, my lady, are we struck out not agreed on the index in relation to our supplementary in the light of my Lord Justice Newey's direction, and we added the respondent supplementary.
And can I just check that the electronic bundles do have our supplementary bundle?
My lord
Which
will be
should
able
have
to.
been at starting at page 213 in the core bundle as filed
Yes.
on a
Yes.
few days ago.
Let's see, yeah.
Yes.
Yes.
I'm
The one I have
grateful.
does.
I'll start with my preliminary remarks. So, Mr. Hutchins was good enough to start by taking my lords and my lady to the terms of section 191 itself. And I would, it's page 14 of the main authorities bundle. And all I would do is remind my lords and my ladies of the, first of all, of the definition itself. A person becomes homeless intentionally if he deliberately does or fails to do anything in consequence of which he ceases to occupy accommodation which is available for his occupation, which would have been reasonable for him to continue to occupy. But also the burden of proof, the standard of proof that the local authority must apply when considering that test, and that is at section 190, which Mr. Hutchins took you to at page 11. For a person to have been found intentionally homeless under that section, the local authority must be satisfied, we see that in 191A, that an applicant, Roman numeral 2, has become homeless intentionally. In other words, if there is any doubt, if the local authority cannot be satisfied on any aspect of the test, then an applicant is not homeless intentionally.
When you say any doubt, you don't mean that the criminal standard applies.
No.
It's good enough the local authority forms the view on balance.
Oh, absolutely, on balance of probabilities.
Yeah.
Which is why I changed the standard of proof. But the point is doubt.
Yes.
And therefore, if there is doubt, it must be exercised in the applicant's favour. We can see that again at section 193, which is the main housing duty that applies to those people who are not intentionally homeless, and that's page 17. This section applies where A, the local housing authority are satisfied that an applicant is homeless and eligible for assistance, and are not satisfied that that the applicant becomes homeless intentionally. So for the lower duty at section 190 to apply, then the local authority must be satisfied, in contrast to all the other matters of which they must be satisfied under the Act, such as priority need and so forth, where they have to be satisfied of the positive case. For intentionally homeless, they have to be satisfied that somebody is homeless intentionally. Otherwise, they have to give the benefit of the doubt to the applicant. And that's reflected in the provisions of the code. It's not in front of my lords and my lady, but it is there, and it will be accepted. And there's a good reason for that. And it's the difference in treatment between those who are homeless intentionally and those who are not. And it does come back to the origins of the Act in the Housing and Homeless Persons Act 1977, because nowadays there are two significant differences. The first is in terms of what might be called temporary accommodation provided under Part 7 of the Housing Act. Because if you are not intentionally homeless, and I start to use colloquialisms, but because it's a bit of a mouthful. If you're not intentionally homeless and section 193 applies, you will be given temporary accommodation until such time, if my lords and my lady go over the page to page 18, as one event as specified at section 193 occurs, and most of those events are the offer and subsequent acceptance or refusal of more permanent accommodation, sometimes through the local authority's waiting list in the form of a Part 6 offer, which is an offer of social housing, secure or assured tenancy from a housing association, sometimes an offer of private rented sector accommodation from a private landlord. But that is what the main housing duty, which is the best that a homeless applicant can achieve, provides. It provides the right eventually to an offer of more permanent accommodation, with the exception of some other unusual circumstances. Lord Justice Newey is very familiar with how that duty comes to an end.
Or not, as we will find out.
We will find out. Whereas if you are homeless intentionally and you have a priority need, back to page 11, there is the local authority's duty is to give the applicant accommodation for such period as they consider will give him a reasonable opportunity of securing accommodation for his occupation. So it's for a short period of time, and there is no specified period. The period is for the local authority to decide, which is the case that Mr. Hutchins referred to, where we were against each other many years ago. But quite frequently it's 28 days. Sometimes it's 14 days, sometimes it's 2 months, but it's that sort of region. And after that, the applicant is on their own, to be blunt about it. So if you are not intentionally homeless, you will be housed until you give an offer, absent some unusual circumstances. If you are intentionally homeless, you'll be housed in temporary accommodation for a short period. Then you're on your own. You won't necessarily have any degree of priority on the local authority's allocation scheme or waiting list, whereas those who have the 193 accommodation do have a degree of priority on the waiting list and have an expectation of an offer of social housing. It's important to understand, and Mr. Hutchins did explain this, that was not quite the position 43 years ago, when the House of Lords considered the case of Wandsworth ex parte Din, because at that time, some 5 years after the first Act had been passed, it was understood that the terms of the Act required the local authority to give homeless people who were not intentionally homeless and who had a priority need what was called permanent accommodation. So council housing or housing association housing, and that's what Lord Lowry had in mind when he's talking about not punishing but organising priorities. That link has now been broken, as Mr. Hutchins explained. But the reason why there is such a clear direction in the Act that the local authority must be satisfied that somebody is homeless intentionally is because the consequences for those who are intentionally homeless are severe.
I haven't quite grasped your point then. I thought you accepted that satisfied means satisfied on the balance of probability.
It is satisfied on the balance of probabilities, yes. I'm not saying there's a higher standard of proof than that, but what I am saying, and it's in the code, it will be common ground, is that where a local authority cannot be satisfied about a particular aspect of the test, they have to give the benefit of the doubt to the applicant. And that's in contrast to where, for example, the issue is whether or not an applicant has a priority need, where it is to a certain extent for the applicant to show that they have a priority need. So there are significant consequences for somebody who is intentionally homeless. That's my first preliminary point, and my second was going to be ground 3, so I have dealt with that. And my third and last preliminary point is that this is not an appeal on the basis that the review decision was irrational in the Wednesbury sense. And Mr. Hutchins characterised the ground 2 as rationality. I say it's reasons, and I will come to that. We don't say that there was only one decision that the reviewing officer could have come to. We say that the reviewing officer applied the wrong test in these circumstances, and that the learned judge was right to identify that and therefore to quash the decision, not to vary it to a different decision that the judge considered would have been the only decision available to Mr. Perdios. That having applied the wrong test or failed to give adequate reasons, then the review decision needs quashing and reconsidering. Can I come on to respond to Mr. Hutchins' submissions about the meaning of the word deliberate? And it follows what a non-deliberate act would be. And Mr. Hutchins is very clear that he is saying an act is only not deliberate, and if I'm paraphrasing wrongly, I will be corrected. An act is only not deliberate if it's committed as a result of duress or undue influence, stroke force, or where a person lacks mental capacity.
Or possibly mistake, I think he allowed for.
He referred slightly to mistake and didn't develop it. He referred to that in the context of taking my lords and my lady to Chitter and talking about other legal concepts. Yes. He didn't say, and of course it's obvious, and I don't mean this as any sort of a cheat point, but there is of course a prescribed subsection in which an act cannot be deliberate, and that's prescribed at section 1912, where it's taken in good faith and in ignorance of relevant facts. So we have that in any event. We say that that is wrong, that following from the clear authority in case law that deliberate is to be given an ordinary meaning and not narrowly construed, it follows that where an act is not deliberate, that must also be given an ordinary meaning, and that neither Parliament nor the Secretary of State in the Code defines what cannot be deliberate. Where we have instances of what cannot be deliberate, as set out in section 1912, subsection 2, and as set out at paragraph 917 of the Code, those are examples or instances. We find other instances in the case law, and it follows that it cannot be right that an act will only not be deliberate in the circumstances that Mr. Hutchins contended for. There must always be the possibility that there are other circumstances, including the circumstances of a particular context, and I'll take you to where I derive that in the authorities. I also make the point that Mr. Perdios did not direct himself in accordance with Mr. Hutchins' test. Mr. Perdios directed himself in accordance with the examples given at paragraph 9.17 of the Code. And he was right so to direct himself, we say. He just subsequently fell into error, and I will come on to that when I look at the review decision. So we say each case where an applicant is raising the possibility that his or her act or omission might not be deliberate has to be considered on its own facts. We make the point in our skeleton example that deliberate is not defined in statute, and the statutory provisions have now been in place for something like 48 years in three different iterations: the 1977 Housing and Homeless Persons Act, the Housing Act 1985, and subsequently the Housing Act 1996, which itself has been around now for nearly 30 years, and itself has gone through various amendments since 1996. At no point has Parliament chosen either to define deliberate or to specify an exhaustive series of instances where an act would not be deliberate. Parliament confines itself to specifying one, and we say leaving open then the possibility of other non-deliberate acts. We agree on the basis of Robinson, Torbay and Devonport and Salford. I don't need to ask my lords and my ladies to look at the authorities, that the word deliberate refers to the acts, not the consequences. Lord Denning's speculation in that respect was wrong. And we agree that deliberate is an ordinary word and is not to be narrowly construed, which is from Lord Justice Waller in Devonport, and we make the point that that must therefore apply to acts that are not deliberate. Where we say Mr. Hutchins starts to deviate from the authorities is when you come to Wandsworth ex parte Hawthorne, which is page 48 of the authorities bundle. And Mr. Hutchins took my lords and my lady to that, so I don't need to repeat the facts. The issue was whether non-payment of rent because she couldn't afford otherwise to maintain her children constituted deliberate. And at page 53, Lord Justice North rejects submission from the council that a deliberate act is a considered choice between two courses of action or inaction, either of which he's able to take, but and therefore including a considered decision to apply the money for maintaining his children, rather than paying the rent. And that at D2E is rejected by Lord Justice North. It's not the purpose of Part 3 of the Act of 1985, so that's the second iteration of the Act, is to house the homeless. Admittedly, it's not part of that purpose to house those whose homelessness has been brought upon them by their own fault, but equally, it is no part of it to refuse housing to those whose homelessness has been brought upon them without fault on their part. For example, by disability, sickness, poverty, or even a simple inability to make ends meet. So at that point, Lord Justice North is going further and envisaging wider circumstances than Mr. Hutchins' characterisation of force or lack of capacity. Now, one could say that the particular issue that he was dealing with, poverty or the simple inability to make ends meet, they must mean the same thing, well, it seems they mean the same thing, can be characterised as force. And that's how Mr. Hutchins did it. But it can't be right that the two examples he gave, and I accept the two examples are not the ratio, but the two examples of disability or sickness could fall into Mr. Hutchins' categories. He doesn't put it in terms of disability or sickness leading to a lack of mental capacity. Appreciate that that point's not being argued before him. What's being argued before him is poverty. But we say what is very clear from this authority is that the context of an act that might otherwise appear deliberate is relevant to whether or not it really is deliberate. In this context, in this case, the context was poverty. But we then go on to two other context cases. And the first is Peretti and Enfield, which is page 87 in the authorities bundle. Now, the ratio of that case was that the public sector equality duty, which we've already been discussing, I will come back to when I get to ground 4, is relevant for a local authority when they are taking individual decisions, not just when they are drawing up policies. That was the ratio. But what is interesting for our purposes about the case is what Lord Justice Wilson identifies in terms of the relationship and disability. In this case, the husband and wife had made various unwise decisions not to pay their rent, as a result of which they were evicted by their landlord. And in the course of their homeless application, they provided information to the extent that they had disabilities, and the husband said that on and off he suffered from depression, for which medication had been prescribed, and that his wife had high blood pressure, acute back problems, and arthritis. And there was some discussion about the extent. They then ticked some other forms that suggested that one of them might have, not have, but and they produced medical evidence. And the Court of Appeal concluded that there was sufficient information in the homeless application for Enfield to consider that they did have disabilities. They rejected Enfield Council's submission that the public sector equality duty of section 149 did not apply to individual decisions, and we don't need to look at that. But at page 100, Lord Justice Wilson starts to analyse why Mr. Peretti's disability, that he'd identified as being depression, might be relevant to a finding that their homelessness was intentional, and it's paragraph 36. Second sentence, there were curious features about the history of non-payment of rent, which I've summarised. It was far from being a paradigm example of willful or reckless non-payment. The non-payment seems to have been precipitated by concern on the part of the applicant that the landlady would refuse to return his deposit. Twice he sought legal advice, presumably because he wished to act in accordance with the law, and twice he ultimately paid rent, which in sums equivalent to his deposit he'd wrongfully withheld. But to her survey of the applicant's unusual history of payment of rent, not easily to be explained, the reviewing officer needed to add both the report of the GP that for at least 13 years the applicant had been suffering a depressive illness, and the applicant's own claim that he was subject to a disability. In the circumstances and irrespective of its validity, the applicant's claim must have been to mental rather than physical impairment. The fact that on the first form he had denied having a disability provided more an example of puzzling inconsistency than any substantial foundation for ignoring the claim on the second form. Taken together, these features of the evidence raised a real possibility that the applicant's acts and omissions in relation to the payment of rent were affected by mental impairment, relevant to whether they were in good faith within the meaning of section 191 subsection 2. If the sentence stopped there, I would be in some difficulty, because it would only be about good faith, but it doesn't. It goes on, or for some other reason not deliberate within the meaning of section 1911. So Lord Justice Wilson there, in obiter remarks, because it's not the ratio is that the public sector equality duty applies, but in obiter remarks is essentially building on what Lord Justice North said in Hawthorne, and is allowing for the possibility that a disability in the form of a mental impairment is relevant to acting deliberately in relation to the definition at section 1911.
Mental impairment falling short of lack of capacity.
Yes, absolutely. And I will come to the code in a moment. Because it's not suggested that Mr. Peretti didn't have capacity, he has depression. And again, I'll be corrected if I'm wrong, but I don't think capacity raises its head anywhere in the report. So it's about mental impairment and whether the knowledge, the information on the form that Mr. Peretti had a mental impairment in the form of depression, combined with the unusual circumstances of the history, raised a real possibility that his mental impairment might, that his act in relation to the payment of rent was affected by mental impairment. And that was something that the reviewing officer should have inquired into and had failed to do. So that's my second example of a context in which an act might not be deliberate because of mental impairment that does not fit into Mr. Hutchins' analysis. The third one is Roman and Southwark. And my lords and my lady, I don't think we're taken to it, but the real choice point from it has been referred to, and I've just lost my page number. Give me a moment. Page 291 in the authorities bundle. Now, that's not a homelessness case. That's a case where Mr. Roman successfully applied to be on Southwark's waiting list allocation scheme, but he was given a lower priority because Southwark's allocation scheme provided that where somebody had deliberately worsened their circumstances so as to produce overcrowding, then they would receive a lower priority on the band. And so the issue was whether or not Mr. Roman's behaviour, which was a decision to bring his family to join him in Southwark, they'd been in Ecuador and in Spain, a decision to spend his money on bringing his family to join him, rather than spending his money on finding affordable accommodation for the family, was a deliberate act. And the result of Mr. Roman's decision to pay for plane tickets for his family to join them is that his family were unable to live with him in a one-bedroom, I think, sort of hostel accommodation, and they found a very small studio flat that was to be that was occupied by the husband, wife, and 3 children. So they were overcrowded. There was no doubt about that. And Mrs. Justice Lang goes through the authorities on deliberate. I'm sorry, I can take my lords and my lady to the actual policy, which is at page 309. Paragraph 70. Section 524 of the policy provides for reduced priority to be given where an applicant has deliberately worsened their housing circumstances. And she quotes the allocation scheme, which is headed deliberately worsening housing circumstances, where there's a clear evidence and a conclusion can properly be drawn that an applicant has deliberately made worse their circumstances in order to achieve higher priority on this register, then reduced priority will be given. And examples include D, deliberately overcrowding property by moving in friends and or other family members who've never lived together previously and or have not lived together for a long time, then requesting rehousing to larger accommodation, which is sort of on the facts of Mr. Roman, although one could say that his immediate family were not that. So the issue was whether he had, as I say, in choosing to spend money and bringing his family over, whether that was a deliberate act. And he submitted at page 310, paragraph 75, that the correct interpretation of the deliberate act provision was that an act was only deliberate if a person intended to do it, in the sense that they had a real choice between 2 or more viable options and voluntarily elected to do the act. And that submission was accepted by Mrs. Justice Lang, which she says 2 pages over at page 314, paragraph 89. She uses those exact words. And she then finds that...
Sorry, I wasn't keeping up. Where does she use the exact word?
I'm sorry, page 314,
Yes, that's it.
paragraph 89.
Yeah.
And that's the ratio.
Yes.
And Mr. Marshall Williams behind me has pointed out helpfully, I'm sorry, that the policy started, so I'm sorry I'm jumping around, the policy started at page 308, paragraph 66.
Yes, that's it.
Of applicants who are statutorily overcrowded, and have not caused this statutory overcrowding by a deliberate act. The paragraph I read to you is an explanation of that within the policy. Mrs. Justice Lang, in accepting the submission, reviews some of the authorities on deliberate. And it's worth looking at them. And it starts at halfway down, page 310. At paragraph 77, I am jumping. I apologise. I should just say the council submission at 76 was that the correct interpretation was that the act was done deliberately if the person intended to do it. It has the opposite meaning to accidental, unintentional, involuntary. It's not part of the definition that it should be done with unfettered freedom of choice or with full understanding of potential alternatives or consequences. So that submission was rejected. And that submission is very similar to Wandsworth's submission in Ex parte Hawthorne, where there was a submission that it was a deliberate act despite poverty. And her review of the authorities starts at paragraph 77 with a very similar case, which was called Flores and Southwark. She just calls it Flores, but I can tell my lords and my ladies it was Southwark, and that was the same, a similar policy of whether the appellant had called overcrowding by his own deliberate act of moving into the property in the first place. And Lord Justice Males, I've done that before. Lord Justice Males, having himself reviewed some of the homelessness authorities, at the top of page 311, paragraph 41 from her quotation is saying that deliberate is an ordinary English word which requires no explanation or glossing. An act is deliberate if it's something which the person who does it intends to do. It need not be culpable or planned. And then at 44, on the facts as to whether somebody has deliberately acted so as to cause overcrowding, artificial on the undisputed facts to regard the cause of the overcrowding as the appellant's decision in Flores 5 years earlier to take a tenancy of the existing accommodation. At that time, he obtained for himself and his family the best accommodation. And at bottom of the page, paragraph 80, we're back with Mrs. Justice Lang. The Court of Appeal judgment in Flores confirmed that an act is deliberate if it's something which a person intends to do. She goes on, it did not directly address the question whether a person can be considered to have intended to do an act where the act was not voluntary because the person has no real choice. And going back to 44, she considers that the reasoning lends support to the claimant's interpretation, which is the interpretation, as I say, she finds to be right. And over the page, at page 312, she looks at several more cases. I'm afraid none of them are in front of my lords and my lady, but the case of Alamiri, which I happened to be in, was about a phrase in the Housing Act of normal residence of one's own choice. And it was whether or not an asylum seeker given Home Office accommodation under what was then called the NAS scheme, who is destitute and was told, you have one offer, you have to go to Glasgow or wherever it was, whether that was accommodation of their own choice. And the House of Lords said that it was not. Destitution in that circumstances did not give the asylum seeker an alternative choice. And at Nowell and Hillingdon, which was a case about causation, it was about the part of section 191, whether or not a deliberate act led to the consequence that an applicant ceased to occupy. So it wasn't about the deliberate act, it was the causation. But in that, Lord Justice Lewison was talking about where there may be multiple causes of a person's homelessness. And in that case, the decision maker must carefully evaluate the facts in order to see whether the applicant's homelessness is shown to be the likely consequence. And he postulates two different forms of causation where you have multiple causes. One is a linear one, a set of dominoes, where it doesn't matter that the applicant did not knock over the last domino if he sets the domino motion, effective motion. And in other cases, there will be parallel causes. and the test would be satisfied if one of those causes was deliberate act or omission of the applicant. So local authorities are not unused to having to consider complicated points of causation, including where there may be multiple causes. The other authorities are there, and as I have said, and they end with Hawthorne, and as I have said at the top of page 314, she finds that the correct interpretation in this scheme, I accept that, is that an act is only deliberate if the applicant intended to do it, in the sense they had a real choice between two or more viable options and voluntarily elected to do that act. At the bottom of page 315, paragraphs 98 to 99, I'm not going to read them out, but she finds that it was not a deliberate act to choose to spend money on uniting the family. They'd been separated for months because of their impoverished circumstances, and that the decision maker for Southwark had failed to give effect to their right to family life in his reasoning and his conclusions, treating it as a secondary consideration rather than accepting that it was a paramount consideration for the family. So from Hawthorne, Peretti and Roman, I say that we have 3 examples of a context where an otherwise deliberate act cannot be deliberate. One is poverty, in the case of Hawthorne. 2 is disability, not amounting to mental capacity, in the case of Peretti.
Sorry, poverty, disability, not amounting to
Mental capacity, in the case of Peretti. And the 3rd, as the example in the case of Roman, is reunification of the family life. And I say that those authorities therefore make it very clear that Mr. Hutchins' narrow construction of a limited set of instances that make an act non-deliberate is wrong. I make the point that there is no authority supporting him on that in, again, over nearly 48 years of this legislation in one form or another having been in existence. And in relation to the submission on deliberate, I end up with the code at paragraph 328. Now, Mr. Hutchins says, well, statutory guidance has the same authority as a textbook, but I mentioned first that section 182, which is not before my lords and my ladies, but we can put it before you, requires the local authority to take the code of guidance into account. That's why it's statutory guidance. And there is well-established authority, and in the homelessness context, it's Nazula Meso and Westminster, where Baroness Hale says that if a local authority is to depart from the guidance, which they can do, but they have to give reasons for departing from it.
In that case, my recollection is that Baroness Hale quotes the code more or less precisely.
Yes.
Is that in relation to suitability?
Yes. Yes.
Is there a separate statutory provision dealing with guidance on suitability?
No.
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 Let me just remind myself.
Suitability is a chapter in the code.
But in terms of the statutory source, is it different?
I think what my lord may be considering.
Probably misguidedly.
No, of course not. There is a statutory instrument that that provides for factors to be taken into consideration on the location of the accommodation in relation to suitability. That might be what my
That
lord
probably is what I have in
has
mind.
in
But
mind.
what Baroness Hale was referring to was the code.
It was the code. Yes, it wasn't another code.
Yeah.
Suitability is chapter 17 of the code, and we're in chapter 9. I'm embarrassed, I know that to that detail, but there we are. It's certainly a chapter. I'm pretty sure it's chapter 17. It's all in one code. And section 182 applies to the whole code.
Yes.
Mr. Hutchins has taken you to paragraph 9.3, 617. I say that these are good articulations of examples when an act may not be deliberate. And they are examples, and I repeat my point that everything we have in front of us in terms of both section 1912 and the code and the authorities are all examples, that there is no exhaustive definition, and that the code provides us with examples. Both counsel were agreed that that was the case before His Honour Judge Roberts below. Mr. Hutchins said, and I'm sure he didn't mean this, but looking at B, he said that the guidance that the Housing Authority has reason to believe the applicant is incapable of managing affairs was the wrong way round, because it had to be satisfied. That's why it's that way round. Because the test for the local authority is that they have to be satisfied that an applicant committed a deliberate act, if they have reason to believe that he's capable, then they can't be satisfied. That's why it's put like that.
But it does sound different. So having some reason to believe doesn't sound like being satisfied.
And to a certain extent, you'd have to take that up with the authors of the code. But my submission is that's certainly what the intention is. The reason that they're saying that is to highlight that they must be satisfied of the matters that they're going to hold against the applicant on the basis that an applicant doesn't want to be found intentionally homeless, and that is a negative thing, a mark of Cain for the applicant, that they can only be satisfied on those matters that are going to lead to his or her detriment, and therefore, if there's doubt, then they have to give it to the applicant. And I would suggest that that's why it's put in those terms. I'm saying suggesting rather than submitting. I'm not putting it any higher than that. But and that's why it cannot be right that a local authority must be satisfied that an applicant is incapable of managing their effects, because it's putting it the wrong way round. It's putting the default position the wrong way round. And the other side of the coin, examples of acts and omissions which may be regarded as deliberate are set out at 920, and again, those are examples. And one of them, of course, is voluntarily surrendering adequate accommodation, which it would have been reasonable for them to continue to occupy. D, 920D. And of course it's right that somebody with no disability whatsoever, fully understanding what they're doing, forget about the consequences of homelessness, who hands their keys in. That's precisely what intentional homelessness was designed to avoid back in 1977. Of course, that must be right. Would my lords and my lady just give me one moment? Those are my submissions on the deliberate and non-deliberate test.
Just to be clear, in your skeleton, I think you do essentially put forward a test.
Yes, I was coming back to Mr. Hutchins rather than putting my positive case. So yes.
So I think the test you're putting forward.
It's in our respondent's notice as well. It is. We say that acts brought about by disability should not be regarded as deliberate. Is that what my lord had in mind?
I can't find it. Maybe it was in your first skeleton that I found it.
So in the core bottom, it's in the so.
Yes, I've got the respondent's notice.
Oh, I see. You'll see it. I don't think it's any different.
No, I think Mr. Hutchins and I are agreed. It's in the respondent's notice, which is page 25.
Sorry, let me
And we certainly, it wasn't intended to be put in a different way in any of the skeletons.
okay.
We hold ourselves to the respondent's notice, and it's 2 sentences. Acts brought about by disability should not be regarded as deliberate.
So where are you reading from? Which page?
Page 25.
of the call.
Yes.
I had in mind that
Did I say something different?
you might have said something different, but I can't now find it. I had in mind you said that it depends what you mean by brought about. I thought you said that if there was a causal connection. That wasn't.
Well, I go on to say in the respondent's notice, second sentence, that we aver that this includes acts where disability or mental health problems play
A significant role. Yes, I follow.
and does not require that disability or mental
Yes.
problems are the sole cause. So in terms of my test, it's
Yes.
page 25.
Yes.
And that is the test that I put forward. And I'm sorry, I spent a lot of time responding to Mr. Hutchins on why he is too narrow.
And it might be said, well, that doesn't really quite fit the code either.
My test.
Your test.
Um,
You explained that Mr. Hutchings' test doesn't fit the code, but
Yes, yes.
Might say,
I,
well,
I
this-
say Mr. Hutchins' test is too narrow.
yes.
I say that my test is the right test given the authorities. I've taken my lords and my lady too. And given that given the C in the code, limited mental capacity or temporary aberration or aberrations caused by mental illness, frailty, or an assessed substance misuse problem. We're not in obsessed substance misuse, but frailty, for example, is a very open and undefined word.
Any mental health problems? I mean, as Mr. Hutchings says, very many people nowadays are thought to have some mental health problem. I don't, ADHD is a mental health problem. So if in some way ADHD played a role in somebody deciding to leave accommodation, that would be
We say a
Right.
significant role, first of all. And the so it's either the cause or it plays a significant role if there is a multiplicity of
Does
causes.
that mean no more than, it's got to be a but-for cause, but it might be one of two or three or more
Yes,
but-for
yes,
causes?
yes. And in terms of the level of mental health difficulty, we say that, first of all, that is not for this court to prescribe except on the facts of this case, which we will come to. And my lord and my lady haven't had extensive medical evidence about all sorts of mental health problems. But the issue principally is, if the issue principally is causation, then Mr. Hutchins' example of lots of people with mild depression, we say doesn't get there. That on an evidence of an applicant who has mild depression and hands his keys in, and I have to be careful not to undermine my own case here because we'll go on to look at the assessment of Mr. Bussandra's mental health, but where there has to be some medical evidence that shows the causation.
Let me just try to test it a bit.
Yes.
So, say somebody with ADHD is receiving therapy from somebody who happens to live close by, and then they move a bit further away so that you could easily get there on the tube, but it's less convenient. And the person thinks, well, I don't want to live in my current flat anymore because it's not as convenient as it used to be. So I'll move to, I'll give up my current premises in the hope that I can be rehoused a bit nearer the therapist's new premises. Is that all right?
No, it's not all right, and doesn't fit with the causation.
Well, it might do,
Because
but
the
for
decision making is not the ADHD.
but,
The decision making to give up the keys is not the ADHD.
but for the ADHD, the person would not be moving, would not be giving up the accommodation.
There is a danger with looking at hypothetical facts without evidence. So we say that here on this set of facts, we have somebody who has a disability, that's accepted. It is a mental health impairment, that's also accepted. and that disability caused him to go over the edge, as it's put in one of the sets of representations, and therefore to choose to terminate his tenancy. And that either caused or was a significant role. I repeat the point that
Wasn't the mental health impairment that caused him to go over the edge, according to the submissions, was it? It was
the theft of it was the mental health impairment, and then it was the theft of the bank statements that caused him to go over the edge
because
in
he
the
had
context
that
of his mental health impairment. Yeah.
context.
Yes. Yes. And I make the point again that we are not saying that there was only one decision that Mr. Perdios could have come to. We're saying he applied the wrong test. I'm so sorry. Yes. Yes. Mr. Marshall Williams, who's had a chance to think behind me, is making the point that in the ADHD example of my lord, the symptoms of the ADHD are not the cause of the decision. Now, my lady's just made a similar point in terms of the facts of my case. I'm aware of that. And one could extrapolate even further on the ADHD example and say, not only does this person have ADHD, but he or she has a number of other conditions that, as a result of the loss of their therapist, sends them over the edge, as it were. Who knows? Yes. We are dealing hypothetically. But my point is that disability is a context. The context of disability is something that can render an act not deliberate.
So because I might think, because I have a mental illness, I'd rather move out of this place. That doesn't undermine the deliberateness of the decision. It's only undermined if it's my mental illness which causes me to make the decision.
Yes. 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 Yes.
And how does all this interact with the reasonable to continue to occupy point? What does this really add?
Mr. Hutchins is right that in many cases the two will be the same, but not in all of the cases. And
certainly, for my part, I would accept it won't be the same, but where does the first limb get you something more that the reasonable to occupy doesn't?
Well, in this case, it might do. If the decision remains quashed and Mr. Perdios has to reconsider it, applying our test, because our test focuses on his state of mind when deciding to terminate the tenancy. And if his state of mind was not deliberate, Mr. Perdios...
Do you mean by that objectively it may have been reasonable for him to continue to occupy, but in his state of mind had an influence on what he actually did?
Well, on the... Mr. Perdios finds that it was reasonable to continue to occupy. With the exception of the PSED point, there isn't an appeal against to this court. There isn't an appeal against this. He made factual findings to the extent that the property was not unsafe for the reason Mr. Bussandra thought it was unsafe. Clearly, I don't accept those. I have clear instructions that the abuse and so forth took place, but there's no appeal against. So we have a factual decision by Mr. Perdios. My client's state of mind, believing that he was unsafe in January 2016, which was either brought about by his mental health, or his mental health was impairment, or his mental health impairment was a significant cause of the decision that he took to terminate the tenancy.
So could you repeat that?
His state of mind, believing that he was unsafe and couldn't live there, was either brought about by his mental health impairment, or his mental health impairment was a significant cause which led him to the conclusion that he could not continue to live there and terminate and take an action in terminating the tenancy. As a matter of fact, according to Mr. Perdios, objectively, the accommodation was reasonable to continue to occupy. So to that extent, my lady, it's subjective because it is focusing on how
His state of mind.
his state of mind as brought about by or significantly caused by his disability. And to a certain extent, Lord Justice Wilson and Peretti is suggesting similar points when he talks about the strange circumstances of Mr. Peretti's decision making around non-payment of rent.
It's complicated here by the fact that his state of mind is a state of mind that relates to whether the property is one that's reasonable to occupy.
Yes.
But it could be any delusion. It could be that he believes he's being told by voices that he must move.
There is a very old case, and it's to do with inquiries, where a couple leave because they believe that the house had poltergeists.
It still makes it unreasonable to occupy, I suppose.
I'm trying to remember whether it was deliberate act or unreasonable to continue to occupy, and I think it was unreasonable to continue to occupy. But yes, reasonable continue to occupy is much more of an objective test. You have to take that person. So if we take Miss Poshte, I mean that was a suitability case, but the point applies. You had to take Miss Poshte with her history of having been a victim of torture and imprisonment in Iran, and having PTSD as a result, and what the window might have reminded her of. And then objectively, Kensington and Chelsea found that that was wrong because the window wasn't as she described, and there wasn't the medical support and so forth. So you do, for reasonable to continue to occupy, you certainly have to take the person as you find them and consider what it is for them, but it then gets considered objectively. I need to, I'm sorry, make one last point about Mr. Hutchins's propositions. And that is where he, towards the end of those submissions, he was saying that, making the point that in English law, the presumption is capacity. We know that that's the case in the Mental Capacity Act, but also in common law, the presumption is capacity. And he took my lords and my lady to chitty on circumstances in which somebody has not entered into a contract because of capacity. And he also briefly referred to criminal law. We say that's not the point. The word here is deliberate, not capacity. We're not dealing with contract or crime. We're dealing with a statutory scheme set up by Parliament for the distribution of social resources. And Parliament has chosen to use the word deliberate. And nobody is suggesting that relevant to deliberate is Mr. Bussandra's ability to try and negate the consequences of his action in terminating the tenancy, the contractual consequences. He had the capacity to enter into a tenancy, and he had the capacity to terminate it.
You're quite right. If he genuinely lacked capacity, then the notice to quit would presumably be ineffective.
We still have an existing tenancy, yes, my lord. 10 years, nearly 10 years after the event.
Well, that depends whether it's voidable or void.
I think it would be void. I may be wrong.
Well,
Anyway, but we don't need to go
Would
there.
have ceased to occupy in any event.
he would have ceased to occupy in any event, but then the local authority would have had, the Guinness Partnership would have had to do so. It's not, that's not the suggestion before, my lords. We can play with that, but it's not suggested that the tenancy was not validly terminated. That's my important point. Can I move on to my submissions on the review decision and the facts? Mr. Hutchins, I'm aware I've got an hour. Mr. Hutchins very helpfully took you through the contemporaneous documentation at length. I'm not going to do the same thing. There are a couple of contemporaneous documents that I do want to draw the court's simply because they may have been slightly overlooked. So if we go to the supplementary bundle, my lords and my lady have already looked at the letters from the GP before he moved to Brighton, and my Lord Justice Newey was kind enough to point out the recurrent depression point that I was trying to make. At page 8 of the supplementary bundle is Mr. Bussandra's contact with Guinness. In fact, while he's still away, but he's found out 2 days earlier about the theft, and that's his email. And I make 2 points on that. The first is that 2/3 of the way down the page, we have a paragraph that starts, "I would like to exchange an ASAP, please." So he wants to move, and he's trying to take action to move that doesn't involve terminating. And he says at the bottom, "I cannot live with thieves. I do not feel secure in Brading Road." And then before he terminates the tenancy, at pages 17 and 18 of the same bundle are email chains between Guinness. And we can see one has to turn the page to the side, we see at the bottom of 17, there's an email chain 11th of January 2016, which is the day before he terminates. And if we go over, we can see what that email was. It's between Guinness people. I've spoken to him. I advised he had not responded to your email. We cannot say how long he may be on the transfer list, and that it could be years. He advised he'll be ending the tenancy. He cannot wait that long. And then in the notice to quit, page 19, he says at the bottom, "I've had to leave my home due to the antisocial behaviour and stealing of all my post bank cards, money from other tenants within the block, !" So this was a man on the 12th of January 2016, when he signs the notice, who already had a history which included recurrent depression, who, when he had moved to Brighton, the GP tells us that his depression and anxiety had been exacerbated. He then experiences the theft of the bank cards, and the contemporaneous documents, once he has the theft of the bank cards, is, "I cannot live with thieves. I do not feel secure." He asks about a transfer or an exchange, and is told that it will take years. So as of the 12th of January, he is contemplating the prospect of staying in the flat, potentially for years, where he does not feel safe with his mental health difficulties. And it was that, and it's set out very well in the representations from his solicitors at page 112. The last 2 paragraphs of that page, the penultimate paragraph deals with the abuse, which is not accepted. And then the last 2 sentences of that, he went abroad because he was not feeling well, the property needed to get out. He was assisted by the family arranging a trip. While abroad, the fraudulent bank transactions happened. The combination of theft, antisocial behaviour and abuse caused his depression to significantly worsen. He instructs that he remembers he felt vulnerable and isolated, an overwhelming feeling of wanting to escape. So this is now the position after the theft, after he knew about the theft. He remembers feeling very unwell and scared about being attacked by the people behind the antisocial behaviour, homophobia and theft. And of course that's not divided up, because that's not his experience, it's not his instructions. These fears added to his desperate feeling he needed to leave and escape. He instructs that looking back, he considers the theft to be the final straw, and that it pushed his mental health over the edge. So on my lady's point earlier about over the edge, we have an existing mental health impairment, which on his instructions is getting worse. There is the final straw of the theft, and that pushes him to a place where he feels unsafe and feels that he has no real choice. And he says, looking back, he says his mental health was significantly destabilised at the time he left, and the decisions he made were badly affected by this severe mental health episode. I don't need to take the court to the extensive medical history. The court, I know, will have read Dr. Wahid's report, and this is a public court. There are various matters that my lords and my lady will have read that I'm not going to go into. But we know that that is a long-standing diagnosis. We know, to a certain extent, we have to put the medical history together from Dr. Wahid and then from Ms. Pisaneschi, who's quoting from medical records. But from those, we know that in 2006, Dr. Falkowski was diagnosing a depressive episode, and in 2010, Dr. McIntyre was describing flashbacks, nightmares, diagnosis, and OCD. And in 2015, he was receiving cognitive behavioural therapy for OCD. And then, as I say, by December 2015, the recurrent depression and anxiety is worse, having moved to Brighton. And then there's no contemporaneous medical evidence as to it worsening as a result of the theft. I should also point out that the review decision says that it does not appear that your recent diagnosis and assessments are significantly different to what you were suffering from in 2015. And that's paragraph 19 of the review decision, which is core bundle 170. And on that basis, if I have understood that finding right, then Mr. Perdios needs to apply the diagnosis in Dr. Wahid's report, which is 2022, to my client's mental health impairment in December 2015, 2016.
That's the moderate depressive episode.
Moderate depressive disorder, moderate, and PTSD, and then symptoms set out by Dr. Wahid. So Mr. Perdios appears to not only accept Dr. Wahid in February 2022, but also accept that that was the case 7 years earlier. Can I turn to the review, just before I turn to the review decision, I'm not going to ask the court to look at any more documents, but because Mr. Hutchins very helpfully took you through each of the review representations, there are 6 of them. What is clear, six letters from GT Stewart. What is clear are the instructions that they were conveying, that he could not continue to endure abuse for a further 2 years. He had no choice but to leave, and no choice and no real choice comes up regularly in those 6, along with, and this is June 2023, an overwhelming feeling of needing to escape, an overwhelming need to escape, and submissions that the act was not deliberate because he had an overwhelming feeling of wanting to escape, did not have a real choice. And we say that those instructions being communicated in 2023 are accurate when one compares them with the contemporaneous documents. What we know of his state of mind from the contemporaneous documents in January 2016. I will go to the review decision and my ground 1. Well, the appellant's ground 1, but it was my ground 1 below, and that is that we say that Mr. Perdios applied the wrong test. And the starting point is page 167. It starts with paragraph 9, under the heading ability to make descriptions. Make decisions. So sorry. And at paragraph 11, Mr. Perdios directs himself in accordance with the code. I don't have a problem with that. I say that he didn't go further and consider the role of the disability. And we see that.
Sorry, let me just get it down.
Yes.
Yeah.
We know that at paragraph 12, the theft of the bank card is accepted, and it's accepted that he believed it was by a neighbour or a neighbour's visitor. And I make the point that that would make somebody feel unsafe. This is a building with flats. It's a ground floor, first floor building. He says there's a communal post box which is locked, so one assumes it's individual post boxes, in fact, that are locked, and one also assumes that those post boxes will be within the building. So we say that it's a reasonable reason.
He says somewhere that he thinks somebody the postman must have left it sticking out.
He does. I think it's in the report to the police. Yes, but it's not unreasonable to feel unsafe, is what I is what I say. So, and then at 13, Mr. Perdios acknowledges the mental health condition, sets it out, including at Dr. Wahid's report, and at 14, I'm not disputing that you suffer from mental health issues. That's correct. I'm happy to that point. From now on, we say he fell into error. This clearly has an impact on your day-to-day activities, but I'm not satisfied that this is to the extent that you're unable to rationalise and think clearly. Now, that's the wrong test. I don't think it's suggested that it's the right test. It does, of course, come from Ms. Pizzessi. I accept that.
And not just her, but from the representations.
They're
He's
then
responding
quoting,
to the
yes.
case that's been made.
Yes, they're then quoting. But Mr. Perdios is a very experienced reviews
He is.
officer. Mr. Hutchins makes that point, the number of times that this court has considered his decisions, and the onus is on him to have the correct test, even if the representations are wrong. So we say that's the wrong turn, and that.
Sorry, this is paragraph 14.
14.
But he's dealing there with the medical evidence, isn't he?
He is. But it's all wrapped up in what becomes his conclusion about the ability to make decisions, which seems to be the phrase he's using for what we are now correctly referring to as a deliberate act on the basis of the statute. So yes, he is taking Miss Pisaneschi and sorry.
Is it Italian? Don't be Pisaneschi.
I thought it was Italian, but
Pisaneschi is the hard C.
Pisaneschi. Well,
oh, we've got an Italian.
we've got this
Confirming my understanding of Italian.
He's taking her. He is yes. He's analysing her reports, and to that extent, he is applying her test. But he falls into two errors. One, he then continues to apply that test, and two, he doesn't apply the test that I say he needs to have applied about whether the disability, and he finds that Mr. Bussandra is a disabled person, whether for reasons of mental health impairment, whether the disability was the cause of the otherwise deliberate act, of the act, or played a significant role in it. So at 14, he says he doesn't agree with Miss Pisaneschi.
So just on that point, I think following my latest question, it's not wrong of him. It's not an error of law to address the expert evidence or the medical evidence that's put before him, and in so doing, to use the language in that medical report and dismiss it.
No.
So his references to that, let's call it a test, but the references to that test, can't complain about that.
No. But what I complain about this sounds dreadful, is that he's not applying my test. By which I mean, in a more legal context, that having identified that Mr. Bussandra is a disabled person, he doesn't then go on to consider whether the disability was the cause of the act or played a significant role. And I accept that he didn't have me over his shoulder articulating that test to him. But in terms of a matter of law, having already directed himself as to the provisions of the code, I say that the authorities show, Princeps, Hawthorne, Peretti, then Roman, that the authorities show that disability can be a reason for an act not to be deliberate.
I mean, he doesn't disagree with that, but you go further and come up with a more precise formulation. I mean, Mr. Pedios is not saying disability can never be relevant.
No. No, but what he does, having analysed the medical evidence in terms of her test, he doesn't, and saying that he disagrees, he doesn't then step back and apply the correct test on the basis of his findings. Because he disagrees with Miss Pisaneschi, but he doesn't disagree with the rest of the medical evidence. And he doesn't apply the rest of the medical evidence to Mr. Bussandra's decision-making in January 2016. Having rejected Miss Pisaneschi, he says, and he starts to do this at 21, I'm satisfied this is a simple case in which you merely regretted moving to Brighton and then sought support to move back to London. So he doesn't.
You talked about context, and
Yes.
some important context in paragraph 12, because he refers there to the evidence that even before the theft of the bank card, he wanted to move back to London.
Yes. Yes, so that's an important context which Mr. Pedios then uses is the wrong word, but that's a reason for him coming to
He places reliance
at
on it.
21. But what he doesn't take into account is the existing history of recurrent depression, that even though he notes it at 12, that having moved to Brighton, he has heightened anxiety and some depression. So that's before the theft. And then the very clear instructions in the representations that given that mental impairment, the theft of the bank cards made him feel unsafe, and that's what's pushed him over the edge.
I mean, specifically in relation to Dr. Wahid, you do have paragraph 15, where Mr. Pedios says he doesn't dispute the findings of Dr. Wahid, that there's mental illness and so on, but he says that's not the same as saying that the actions were the result of an inability to manage your own affairs, mental illness or temporary aberrations. So he's got the code in mind there, evidently.
He has, but he's not applying it.
Well, he says, indeed, he stated that you were suffering from a moderate depressive episode. So what he's saying, and you obviously disagree with him, is, look, I'm thinking about the code, and moderate depressive episode doesn't do it.
In February 2022, doesn't do it.
Doesn't do it. And I don't think he's not saying, well, there was only a moderate depressive episode in 2022. I shouldn't assume that there was one in 2015 to 2016. He's saying moderate depressive episode doesn't do it.
At all, ever, yes.
Well,
Yeah.
yes.
Sorry, that's me going too far. But yes, but that doesn't. February 2022, Mr. Bussandra has a moderate depressive episode at a time when he is not living in a place where he feels unsafe. Happens to be temporarily accommodated at that time, which is not great, but there's no complaints about it. What he doesn't do, except in fairly general terms, where he says at one point that I accept that having your bank card stolen made you feel that it was more upsetting. He says that at 31. I'm not disputing that with your pre-existing mental health issues, which is the theft, may have been more upsetting for you, and you may have been less able to deal with it. And then he goes on, and that's under reasonable to continue to occupy. He doesn't deal with that very clear case set out by G.T. Stewart of an existing mental health impairment that was already exacerbated, and then you have the going over the edge. And if he'd had, okay, forgive me, sorry.
So paragraph 26, he says he's not satisfied the decision that accommodation was due to various things, including mental illness. So he said that, but are you saying that's not underpinned by a finding that allows him to get to that conclusion?
Yes, yes. I'm grateful for putting it better than I did. Yes, I do, because the most he said, as my Lord Justice Newey said, is that he said Wahid's diagnosis of moderate depressive episode doesn't do it, but he's not engaged with what there was, and clear instructions about not feeling safe, and in that context being pushed over the edge. And he does to a certain extent think his way around some of that. At paragraph 19, he engages in the possibility of more serious symptoms of mental illness, hallucinations, and unstable psychotic tendencies, and so forth. So he's dismissing, not dismissing in a pejorative way, but he's finding that there isn't that level of mental illness, but he's not engaging with what was directly said. And I say that if he had had the test as I had formulated it in mind, particularly that my client's mental health was a disability, which he does find, if he'd had that in mind, rather than, I say at 25 he repeats the code without having properly put his mind to it, if he'd had the way I've put it in mind, then he might potentially have come to a different conclusion. I should deal with the no option point. He does at 22 say, you told Dr. Mannon, it's right at the last line on 22, you told Dr. Mannon you had no option to leave Brighton and return to London. Dr. Mannon is March 2017, so it's just over a year after the relevant events. So Mr. Purdius deals with no option, not so much as put by G.T. Stewart, but as said to the GP just over a year later, and he dismisses it. He says, for me, it's evident that this is a simple case that you wanted to move back to London. But again, it's not at all clear how he comes from, he said that in 2017, and I now reject it. He's not taking into account what we know about the contemporaneous events. And more to the point, his contemporaneous statements of feeling unsafe. And those contemporaneous statements were not only in front of Mr. Purdius, but had been made very clear by G.T. Stewart.
Just unpacking it.
Yes.
As you've explained more than once, you don't say that Mr. Purdius could not rationally have arrived at the conclusions he arrived at. So in the context of ground one, the complaint is wrong test.
Yes. 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 And despite the references to the quotation from the code, which include the reference to mental illness, he is in fact applying the wrong test, because he is not considering, did the disability was that the cause of the act, or did it play a significant role?
Well, insofar as the question is, was it the cause of the act? That is precisely the way he puts his conclusion. It isn't just he identifies the test. That's how he expresses his conclusion at 26, isn't it? It was not due to an inability to manage your own affairs, etc.
Yes, that's how he expresses it, but that's not. If he had in mind that this was that my client had a disability at the time.
Well, he did. I mean, it's clear from the report as a whole that he was well aware of. I mean, I think you say that he knew there was a disability. In terms, I mean, you may say that when he says that in terms, that's not in fact what he's done. If you look at the paragraphs before, I think that's what you have to say there, isn't it? That when he says that's the decision he's making, that's not the decision he's making.
Yes, that is what I have to say when he says that's. I'm sorry, because he comes to his factual conclusion is I'm satisfied that it's a simple case that you wanted to move back to London. That's his factual conclusion.
Yes.
And in coming to that conclusion, he has failed to take into account that my client has a disability. He's considered various forms of mental health impairment, the more serious ones and so forth, which he rejects. You don't have psychotic tendencies and so forth. He rejects Miss Pisanescu. He says that he acknowledges the contemporaneous medical evidence, but he doesn't then apply that and the representations to the decision in January 2016. Save that, he doesn't apply it. What he does is he steps over that and then says, this is a simple case. But he doesn't apply it.
I mean, the proposition this is a simple case represents his conclusion, doesn't it?
Yes, of course, yes.
Yeah.
Yes. Would my lord and my lady give me a minute?
Just, I think the conclusion of 26 is based on reasoning which applies to rational, I think, clearly tested things. So he got stuck at that
I'm going to move on in a moment to grounds 2, but what we would say in relation to ground 1 and this series of reasoning between paragraphs 9 and 26 is that because Mr. Perdios is dealing with the test as put forward as whether he could rationalise and think clearly, that then seems to be the test. He's not just disagreeing with Ms. Pisanescu. He goes on and he effectively applies it. So he applies it at 14, where he says he disagrees with Ms. Pisanescu. He applies a form of it at the end of 15, where he says the symptoms reported did not include you being unable to make rational decisions when he's dealing with Wahid.
I mean, it's certainly the case that you find this formulation recurring through the decision, normally in inverted commas.
Frequently, yes. And my Lord Justice Newey made the point this morning that she doesn't say that, she says likely, and I did look over lunchtime and she doesn't say it in absolute terms, she does say likely. So he seems to be quoting.
It's not quite a quotation.
It's not accurately quoting.
In that sense, it's a quotation favouring your client, or a misquotation favouring your client.
Well, but it repeats throughout. So it's
Yes.
at paragraph 16, it's at paragraph 17, it's at paragraph 18, it's at paragraph 90, it's about significant mental health issues that meant you did not have the ability to make rational decisions, and then 21 is the 21 unable to rationalise and think clearly, again in quotations, and his conclusion that it's a simple case. And 22 is his test is because you could not make whether you could make rational decisions at that time, and that's also there in 25. So he's misled to a certain extent by that phrase.
Really, what he's saying is that he's bookended this section with the code test at the beginning,
Yes.
and the code test at the end in his conclusion, but his reasoning throughout it does not apply.
He's
that
not
test.
thought it through. Yes. 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 Is there any other on ground one?
Yep.
So I move on to ground two. So we say ground two is a reasons challenge by us. We do not say that Mr. Perdios had to, that Miss Pisneski's decision was determinative. We don't say that. But we say that the reasons he gives for departing from it are not to the standard of reasons as required by the statute. And I'm only going to take, my lords and my lady, I'm going to mention 5 authorities. I'm only going to take, my lords and my lady, to one. The first is that...
Sorry, can I just clarify one thing?
Yes.
Is this a challenge that the reasons he gives in his decision are not thorough enough reasons for the purposes of making a decision, giving a decision, or is it that he hasn't got sufficient reason for dismissing the evidence?
No, it's not the latter.
It is the former. It's the decision itself lacks reasons.
So there is a duty to give reasons, and that's at section where a decision is against the applicant, and that's at section 202, subsection 3. There is a well-established law. I think we both quote it. The House of Lords in South Bucks and Porter, and my lords and my ladies don't need to look at it now. It's page 65 of the supplemental bundle. Reasons for decisions must be intelligible and adequate and enable the reader to understand why the matter was decided as it was and what conclusion was reached on principal important controversial issues. Reasons challenge will only succeed if the party aggrieved can satisfy that he or she has been genuinely has been substantially prejudiced by a failure to provide an adequately reasoned decision. So if there's no prejudice, it doesn't matter that my lords and my lady might think it's not adequately reasoned. And it's in the bundle. I don't need to take the court to it, but Lord Justice Lewison in Alibiket and Brent said that the purpose of the giving reasons were twofold and that it was not the function of the review decision to provide a treatise on housing law. There are 2 authorities on where a decision maker, a non-medically qualified decision maker, is dealing with medical advice. And the first is Charlotte and Birmingham. And in that case, there was conflicting medical evidence. Sorry, I'm in the wrong bundle. And Mrs. Charlotte, it was all about whether or not Mrs. Charlotte was vulnerable for the purposes of priority need, and she put forward evidence which included that from a consultant psychiatrist. Birmingham had that evidence considered by their medical advisors, now medical, who were, and the person who considered it was in fact a GP. And what is said in Charlotte, which for some reason I can't, here we are, it's page 57, is where the report starts. But what is said by Lord Justice Sedley in Charlotte is that where a decision maker has to consider competing medical advice, then they need to take into account the relevant qualifications and also take into account, as was the case in Charlotte, whether or not any of the medical practitioners giving the advice have examined the applicant, because Birmingham's, the advisors for Birmingham, as is normal, gave advice on the written reports they didn't, whereas the written reports came from treating or instructed psychiatrists. I've slightly paraphrased Lord Justice Sedley, but that's what he says. And the second one is Geest, which is Geest and Lambeth, which is page 219. And that was quite similar in that Mr. Geest had put forward a report from a distinguished consultant psychiatrist who had interviewed him and examined him on instructions from the solicitor. And that report had been considered by two psychiatrists who provided medical advice to Lambeth, but they had lesser qualifications than the consultant psychiatrist. They were members of the Royal College of Psychiatry. She was a fellow, and of course, she had seen Mr. Geest, and they had not done. And what is said at page 240 is that is that the decision maker needs to take into account, sorry, I'm doing two things at once. Lord Justice Henderson says that at the bottom of page 239, the evidence from a distinguished consultant psychiatrist directed to the key legal issue and point could not, in my view, be disregarded. If the review officer was going to depart from it, I think it was necessary for her to provide a rational explanation of why she was doing so. And then going on, applying the benevolent reading at the top of page 240, Lord Justice Henderson was unable to find any such rational explanation in the review decision. And on that basis, that was an error of law. And despite a submission that there was no substantial, it was highly likely that the outcome would not have been substantially different, then it was right to quash the decision. Here we don't have competing medical advice. The medical evidence all comes from my client, and it is Mr. Perdios doesn't obtain advice on the contents of the report, and it is accepted that Mr. Perdios accepts the medical evidence save for Ms. Pisneski. The first point I would make, as the judge made below, is that she is an expert. She is qualified to diagnose mental health conditions, to treat and prescribe medication. She sets out her qualifications in all of her reports.
Mr. Perdios doesn't actually disagree with that, does he?
No, but let me go back to the review decision. But he does need to take that into account when disagreeing with her. So his analysis is at paragraphs 13, 14 and 17. Of her reports. So he doesn't say he disagrees with it, but it's not obvious that he's treated her report with the appropriate degree of respect for her qualifications. It's also not obvious that he fully understands that she was treating him and indeed was seeing him weekly. She had been seeing him weekly from April 2023. Her first report is July 2023 and her final report is January 2024. So by then she had been seeing him weekly for some 9 months. Mr. Hutchins can of course rely on that to make the point about her reproducing his account. I rely on that to make the point that she acquired a good understanding of him. Mr. Perdios, of course, and this is not a criticism, but he hadn't met my client. So he needs to take that into...
But she didn't see him at the relevant time, as
No.
she acknowledges.
No. Everybody is doing a very, very difficult exercise in providing, as it were, a retrospective diagnosis. Everybody's doing that, and everybody acknowledges that, as my lady said, as she acknowledges, and Mr. Perdios acknowledged. So it's an extremely difficult task.
Mr. Purdius's reasoning doesn't give any hint that he's dismissing her as an expert.
But he dismisses what she says,
That's totally
and it's
different.
not obvious that he accepts her expertise. He doesn't go out of his way to say, I don't.
He treats her, and where he deals with her evidence is in the context of medical evidence.
Yes, it is. The judge below found that he didn't acknowledge the expertise, and we say that it's not at all clear that he does. I accept the point that it comes within the medical evidence. She is qualified to diagnose, and she diagnoses
He actually says at paragraph 13 that she confirmed this diagnosis. So he doesn't seem to be dismissive of her.
he's dismissive of her opinion that as to what happened some years earlier. He's dismissive of that.
Well, quite often judges even dismiss an opinion. It doesn't mean they're dismissive of the expert. They're just weighing up all the evidence.
No, but I suggest one of the things that's wrong is that it's not clear that he understands her expertise. That's not my sole point. And I've made the point that it's not clear that he fully understands the degree of knowledge she has about Mr. Bussandra. But that's not it. That's not just it. So when we look at 13, she's clearly putting forward an opinion, which, as Lord Justice Newey said, was an opinion that he was likely to have been experiencing a major depressive episode. And that, of course, I say helps me because it shows how careful she was. And I need to make this other point about her care, which Mr. Hutchins obliquely referred to, because, of course, it's actually her third letter, but it's her second letter on the point, which is that of the 17th of October 2023. She makes a point of conducting this very difficult retrospective diagnosis on the basis that no antisocial behaviour occurred and that it was only the theft of a bank card. Now that, of course, creates difficulties both for her and indeed for the legal team, because, of course, Mr. Bussandra is continuing to give his account, and his account he cannot separate. It's as far as he's concerned, he experienced this, and it's not possible for him to separate that. But she says very, very clearly that she has written the letter on that assumption. So she's not simply taking his account. And we say she's not putting that statement forward and then reneging from it. She's making it very clear that on the assumption that there was only the theft, nevertheless, it was still likely that he'd been experiencing a major depressive episode and that he did not feel safe in the property. The other indication of her seriousness is the final letter, which is January 2024, which is page 133, and that's where she reviews the bank statements. So having been told through the solicitors of Mr. Purdius's provisional view, having reviewed the bank statement, she does the same thing. And on the basis that she is an expert, one has to assume that she's properly concluded that having reviewed the bank statement, she's not changed her conclusion, which is what she says. One of the things that is important about her three reports, and indeed about the representation from G.T. Stewart, is that they do distinguish between the decision to travel to Europe, which was taken at a time he'd moved to Brighton, he wasn't pleased about it, and he decided to move to Europe, to travel in Europe, and whilst on his travels discovered about the theft. And then subsequent travel, having returned and having dealt with reporting to the police and so forth, and terminating his tenancy, when he goes to Hull. I think he goes to Hull just before he terminates the tenancy, but it's after his return from Europe. He goes to Hull, where he knows nobody. That's in the representations. He gets the coach to London, and then subsequently at the end of January he's in Portsmouth. And she makes the point that based on his instructions, that the decisions to travel at that point were made in response to the depressive episode that he was experiencing at the time, and that she, having reviewed the bank statement, this did not change her view. And I'm on the last report, page 134. Mr. Bussandra has explained that he was not travelling away on holiday at that point, but was trying to escape, and that his mental health at the time would have affected his judgment and decision making. So she, having reviewed the bank statements, does clearly see the theft as the going over the edge, whereas Mr. Perdios, in his detailed review of the bank statements, comes to a conclusion, and again it's throughout the review decision, that his travelling around, whether it's in Europe or subsequently to Hull, London or Portsmouth, confirms Mr. Perdius's view of it being a simple case that he regretted the decision to move to Brighton. So,
Sorry, is that, which paragraph is that, just 16?
16,
Thank you.
yes. Now he says, when you return from holiday, having been informed of the theft of your bank cards, you were able to travel to Hull and get the coach to London. So in terms of setting out what he's told, but when he then analyses the travel, he doesn't understand that the significant event, that the theft of the bank cards, meant that he felt unsafe. So we say that she's an expert, she has knowledge of him, she behaves objectively and creditably in terms of approaching her opinion, having on the assumption of no abuse and looking at the bank statements, and she still comes to a clear opinion. Mr. Perdius does not agree, but I say it's not clear why he doesn't agree with the only medical opinion that is providing this retrospective diagnosis. He doesn't engage, he just says he doesn't agree.
Is that fair? I mean, he does give, in the course of a long decision, multiple reasons for the view he arrives at.
Well, he says, I'm sorry, there is at least one point where so if we look at 13, he makes the point that Miss Piscinelli didn't know him in 2015. That's not enough, because she accepts that. At 16, he says that Miss Piscinelli relies on letters written by Dr. Cattell in 2015. But again, that's not enough just to discount her retrospective diagnosis. And at the bottom of 16,
That's not why he's discounting it. He's discounting it by, he says she relies on that, but there's other evidence.
he says she relies on that, but your bank statements show you going out regularly, and that's where he falls into the error of not realising that one could go on holiday in Europe for all sorts of reasons. When you discover about the theft of your bank cards, given your mental health impairment, then you feel unsafe, and you subsequently travel to Hull and Portsmouth and so forth for other reasons. He doesn't, although he says having been informed of the theft of your bank cards, he doesn't show that he understands that the representation made to him was that the second set of travel was because he felt unsafe. Ms. Beneshi stated you must have been feeling unsafe and intimidated, but your bank statements show you doing most, if not all, of the things an ordinary person can be expected to do, whereas she had said that's why he's travelling, because he needed to escape.
That part of paragraph 16 might be the strongest point you have on this ground, might it?
I'll take that. I just need to...
Because there he's expressing a view.
Yes, I'm sorry, I've got behind in my notes, so let me find what else he, as it were, holds against her, and that's at 17, and that's the travel point again. He puts it in relation to the representations from G.T. Stewart, but again, that he's in the middle of that. He says this does not mean that you had a major depressive episode in which you're unable to rationalise and think clearly. So again, he's referring back to Pitaneschi without saying so. And he's not acknowledging that Wakefield and Hull and so forth were in the context of him feeling unsafe and needing to get away, which comes from Pitaneschi and from G.T. Stewart.
Where, just as you said, you're doing most of the things that an ordinary person would expect to do at paragraph 16, saying people get away. So
Yes, he's doing the same thing.
it's the same.
It's the same point, yes. So from that, it's clear he does reject Pitaneschi, but as I say, this is a reasons challenge. We say, indeed, I could make a cheap point and say the fact we spent 20 minutes on it confirms this, but that is too cheap. We say that his reasons for rejecting Pitaneschi are not proper, adequate and intelligible, and allow Mr. Bussandra to understand why that expert medical opinion has been rejected. Can I spend 5 minutes on PSED?
Yes.
So I agree with Mr. Hutchins. It's not about the extent to which PSED is specifically referred to as it is in 2 paragraphs. It's about whether the proper reading of the review as a whole shows compliance. The one authority I want to take my lords and my lady to on this, which Mr. Hutchins didn't do, is Lomax and Gosport, which is at page 165.
In the main bundle.
In the main bundle. Miss Lomax was a disabled lady who lived in South Devon. She wanted to move to Gosport. She was very isolated where she lived, and indeed was about to become more isolated because her carer was moving away. But she had a tenancy, she had a property. The Gosport Council decided that she was not homeless, and that her accommodation was reasonable for her to continue to occupy. In doing that, Gosport Council took into account, as it was entitled to do, the number of households on its waiting list. What it didn't do, and thereby breached the public sector equality duty, was consider the number of those households who were disabled. And on that basis, the decision was quashed and sent back for reconsideration. And what, at page 177, Lord Justice Lewison accepts a proposition from Counsel for Gosport, which is Mr. Lewin, at paragraph 43. He proposed the following structure: a sharp focus on whether Miss Lomax was disabled, a sharp focus on the extent of her disabilities, a sharp focus on the likely effect of the disabilities when taken together with any other features on Miss Lomax for as long as she continued to occupy her property in South Devon, a sharp focus on her particular needs in relation to accommodation which arise from her disabilities and the extent to which her current accommodation meets those needs, a comparison between her accommodation needs and the accommodation needs of people without her particular disabilities, a recognition that when considering whether it was reasonable for her to continue to occupy her property, Miss Lomax might need to be treated more favourably than others without her disability. And at paragraph 45, Lord Justice Lewisham accepts those points as a submission. They're supported by the EHRC, and they follow because, of course, the previous authorities, which Mr. Hutchins did take you to, were all about the sharp focus in relation to priority need and vulnerability. So this is the first time, and indeed that the test of reasonable to continue to occupy has been the PSED in relation to that has been set out. It's never been set out in relation to intentional homelessness. And there is also authority, which we both quote in our skeleton arguments, to the extent of if there's not a sharp focus, then the mere recitation of the public sector equality duty does not save the decision. So the substance not form point works both ways. If the only compliance with the PSEB appears to be reference to it, then that's an error of law. If there's no reference to it, but on a reading as a whole, then there is the adequate sharp focus, and there's no error of law. So in the proceedings below, then Mr. Marshall Williams, sitting behind me, put forward two sets of, as it were, sharp foci in relation to the two matters that Mr. Purdius had to consider. And they're in the judgment at page 113 of the core bundle. And Mr. Marshall Williams was deriving those both from HOTAC, but more importantly from Lomax. So at paragraph 117 of the judgment, Mr. Marshall Williams submits that in considering whether the act was deliberate, the review officer's approach should have been to ask what role the appellant's disabilities had in his decision to leave, and then ask whether it should be considered deliberate in light of that. Specifically, that meant to focus sharply excuse me, on the specific aspects of his impairment, such as feeling unsafe, that were relative to his actions, to focus sharply on the effect his impairment had on his decision-making and actions in the particular circumstances, to focus sharply on how his needs arising from his disability might require him to be treated more favourably in terms of considering whether his decision to terminate his tenancy was deliberate. And at 19, then he puts forward four, again, sharp foci that could be relevant to reasonable to continue to occupy. And His Honour Judge Roberts accepts that at page 115, paragraph 124, accepts Mr. Marshall Williams' submission that the review officer paid no more than lip service to the PSEB. In short, the review officer said, I've advanced equality of opportunity. He does not say how he's done this. There's no reference to it elsewhere in his decision, other than his bare assertion. I find this as an example of formulaic box ticking. Similarly, in a like manner, the respondent says he's considered the possible need to treat the appellant more favourably than another, but does not say how he's done this. Another example of formulaic box ticking. And then at 125, the review decision does not focus sharply on two of the matters. His Honour Judge Roberts found that there was never an appeal on the PSED in relation to reasonable to continue to occupy. We say that's not true, and not true is wrong, that is wrong, and we point in our skeleton to where actually reasonable to continue to occupy comes up in the grounds of appeal below. My job now is to show you where in the review decision we say that there has not been a sharp focus. So we go back to the review decision at 125. Sorry.
It's 164.
164, I'm very grateful. And reading it as a whole, then he accepts that that Mr. Bussandra is disabled, and in a sense, the sharp focus on the extent on. We say that there's no sharp focus on the specific aspect of his impairment, such as feeling unsafe, and that there's no sharp focus on the effect the impairment had on his decision making. We've looked at those paragraphs. I accept that. I'm not going to look at them again, but for the reasons that I said under ground one, that hasn't been considered in the proper sharp way. And of course, what has also not been considered is the extent to which his disability might mean that he should be treated more favourably.
How does that work?
Well,
If the statute says, if X, you are intentionally homeless, what scope is there for treating somebody more favourably?
the requirement that the local authority has to be satisfied. Back to doubt. If there is doubt, and it's doubt about a disabled person's decision making.
Does this ground add anything then to grounds 1 and 2?
The second part of the ground in respect of reasonable to continue to occupy, we would say does. And we also say that it is important because of the importance of the public sector equality duty. And that, yes, if my lords and my lady find that I'm wrong on ground 1 and the test was correct and was properly applied, the question then is whether there's a sharp focus, and I entirely accept I'm on the back foot on that, but it is still a separate exercise, as the authorities have made clear,
Yes.
as Lord Neuberger made clear in HOTAC, that requires a slightly heightened degree of scrutiny by the court because it is a specific legal set of reasoning that the local authority has to consider. And so that's what we say in relation to deliberate, and in relation to the sharp focus and reasonable to continue to occupy, what we say that the glaring lack of sharp focus is that Mr. Bussandra had been told that a move for a transfer would take years. So in terms of whether it was reasonable for Bussandra to continue to occupy, the legal test is very, very clear that that test has to be applied looking into the future in the long term. That's the case of Ali and Birmingham in the House of Lords. Specifically in this case, it's a set of facts where he's told that he's likely to stay there for years. And Mr. Perdios failed to have the sharp focus as to what Mr. Bussandra, with his mental health impairment in January 2016, feeling unsafe, albeit only feeling unsafe because of the theft of the bank cards. I appreciate how artificial that is, but only on that basis, whether it was still reasonable for him to continue to occupy for a matter of years, or again, whether in these circumstances he should have the benefit of the doubt and be treated more favourably than others. Would Mr. Hutchins says that that the judge conflated the procedural PSED duty with a substantive duty to accept the case on review, and we say that's clearly not the case. When you look at the judgment, he directs himself very carefully through HOTAC, HAC, Lomax and McMahon, and directs himself that it was not a freestanding duty. And we also we're not suggesting that the public sector equality duty only results in one result. Again, and this is my final point, I'm checking with Mr. Marshall Williams, the appeal to the judge was that the errors of law meant that the review decision had to be quashed. And if you're with me and dismiss this appeal, then that would be the case. And Mr. Perdius or another review officer has to consider it. My lords, I hope that's it. Would you give me a minute?
Yes.
No, my team behind me is happy to that
And I
extent.
don't detect any more questions, so thank you very much, Ms. Davis. Mr. Hutchings, I hope you're going to be brief.
There's an enormous pressure on me at this moment to be as brief as humanly possible. So first of all, ground one comes to this. The respondent accepts that Mr. Perdios purported to apply the right test. Nevertheless, you are invited to infer that he applied the wrong test. And that's a pretty tricky argument in my submission. If one looks at the review decision, I don't probably looked at it enough for today, but basically pages 167 through to 172, and I think we've got paragraph 11 right test, paragraph 14 wrong test, paragraph 15 right test, paragraph 21. So that's the simple case. I mean, there's a point on that. It doesn't matter which test it is. He clearly rejects it, but whatever test it is, the reviewer is clearly of the view that whatever the test is for, did the respondent make this decision significantly influenced by his mental health problems? The reviewer is basically of the view that the answer to that question is no. We've also got paragraph 26, right test.
I mean, as you say,
Paragraph 31, right test.
we have been through this quite a lot.
You've done you've done enough of it for a day, but it's an entirely pedantic argument in my submission that because Mr. Perdios is dealing with the evidence and a submission or representation as it is presented and rejecting it as it is presented, that he's thereby applying the wrong test. All the more where that is sandwiched in between paragraphs where he clearly applies what the respondent says is the right test. So in my submission, as now formulated, this ground has to fail.
The real question is whether it, when he comes to the conclusion he does at paragraph 26, that is actually underpinned by proper findings. And
But that's not ground one, my lady. Ground one is he applied the wrong test.
no, but as we've noted, he expresses the right test at 11 and 26, but is his conclusion actually supported by his reasoning?
But that's ground two.
No.
But as I understand it, ground one is he applied
Yes, although he
Wrong
stated the
test.
correct test at parts, he in fact
applies
based
the
his
wrong
decision on the wrong test, I think is the argument.
test. Well, I don't accept that for a moment. And a lot of the submissions my own friend made were based on a particular construction of the evidence. And one has to bear in mind it's for Mr. Perdios to interpret the evidence. And this idea that his case was that it was all about the bank cards, in my submission, that does not stack up. His case was clearly, I was scared, I went abroad to escape. The theft of the bank cards was the last straw that pushed me over the edge. And the problem for the respondent is that Mr. Perdios rejected that factual case. There's a clear finding, paragraph 32 of the review decision, which rejects the basic underlying facts for that. And if one looks properly at the representations that were made, as well as the medical opinions of Miss Pisaneski, they are based on what he told her about how he felt at the time. And it's clearly based, as he says, on the antisocial behaviour, abuse, and so forth. And so it is impossible to disentangle the medical opinion from that factual substratum. And as a matter of common sense, they are very closely interrelated. So that I do not accept that he applied the wrong test, looking at it as a matter of substance. One has to see it in the context that he's rejected the basic factual basis for both the medical opinion and the representations, or a large part of it. Ground 2, it said this is not a rationality ground, it's only a reasons ground. If it's purely a reasons ground, in my submission it's absolutely clear. You only have to read paragraphs 13 to 21 of the review decision, plus paragraph 32. You ought to read it as a whole, but if you read those paragraphs, it's absolutely clear why he's rejecting opinion. If it's just a reasons challenge, it's clear. My learned friend then went on to say, well, it's not clear that he took into account this or that. Her phrase was, needs to take into account. That is not a reasons challenge. That's a rationality challenge. Failing to take into account a relevant consideration is a rationality challenge. And I just need to draw your attention to, although it's very well known, yes. So within the supplementary bundle of authorities, we have Porter, which is possibly the leading authority on reasons in public law administrative decisions. It is tab 4, page 65. Obviously, one always quotes paragraph 36 within Lord Brown, which is sidelined, possibly too well known to take you through. But I'm just interested in one particular point here. What he says, summarising the case law that went previously, is the reasoning must not give rise to a substantial doubt as to whether the decision maker erred in law, for example, by misunderstanding some relevant policy or some other important matter, or by failing to reach a rational decision on relevant grounds. But such adverse inference will not readily be drawn. Right? And in that formulation draws on the analysis of previous decisions, many of them planning decisions. One was the Bolton case, paragraph 34 on the previous page. It's Lord Lloyd. This is well known for rejecting the proposition that an administrative decision must refer to each material consideration. So, but then Lord Lloyd goes on, since there's no obligation, this is right at the bottom of page 25, since there is no obligation to refer to every material consideration, with only the main issues in dispute, the scope for drawing any inference, the inference suggested being that the decision maker has not fully understood the materiality of the matter to the decision, will necessarily be limited to the main issues, and then only, as Lord Keith pointed out in the ex parte Lonro case, when all other known facts and circumstances appear to point overwhelmingly to a different decision. So the point is this, if you read the reasons, if a submission is made that the decision maker didn't take into account a relevant consideration or did not understand its materiality, I think those were submissions made by my learned friend. then you have to ask yourself whether all other known facts and circumstances appear to point to a different decision. In other words, the only explanation is that he must have failed to take into account her qualifications, or failed to observe that she'd been seeing him weekly, or that he had misunderstood the representation. That is summarised by Lord Brown in his summary formula. Such adverse inference will not readily be drawn. But the origin of it, it's quite a stiff test. So if it said it's a reasons challenge, but there were submissions about rationality. So if the reasons on their face do not disclose irrationality, and you're being asked to infer from the stated reasons that the decision maker failed to take something into account, you have to be satisfied that unless he failed to take them into account, he ought to have reached a different decision. And it's quite an uphill task on irrationality. So we say the reasons are perfectly clear. The attempt to elide that into a rationality challenge failed. My submission is that ground 5 PSED does not actually add anything on the facts of this case, where you've got decisions absolutely focused on mental health, effect on decisions, effects on reasonable to continue to occupy. That only leaves the interesting point in this case, which is the test, which may be that maybe we don't get there. But I just want to summarise for you my response to the way my learned friend put her case. I was aware that she was trying to trap me in this fool's errand, and I tried to step around it, but she still kind of made me fall into it. So or at least she acted as if I had fallen into it and I hadn't stepped around it. But my submission to you was, I'm trying to avoid the fool's errand of providing a comprehensive list of what is not deliberate. But one example is where a person is not legally responsible for their acts because of their mental disability. And here the general law provides the answer. The test is mental incapacity. The code, broadly speaking, seeks to mirror that at 917B to C. But if the code is wrong, of course the local authority has to apply the law. And my footnote, page 10 of my skeleton, produces an authority for that, which is pretty obvious. It was actually a review decision by Mr. Perdios. It's got two other quick points. The first is my submission about personal responsibility and an act not being deliberate because the actor lacks personal responsibility is not inconsistent with the no real choice case law. That's a different point. Whether the housing circumstances force someone to leave is dealt with substantially by the reasonable to continue to occupy test. And I don't accept that subjective in the sense that it doesn't, if it's implied, that doesn't take into account mental health. It has to be reasonable for the applicant to continue to occupy so that it clearly takes into account mental health problems. And that's why we have all these cases about panic attacks in lifts or looking at windows that remind you of your past trauma and so forth. My last point is just that Pieretti doesn't help. And I can probably just provide you with the references. Within the original authorities bundle, page 93, I don't suggest we go there right now, paragraph 12, Lord Justice Wilson, as he then was, set out the guidance. So he quoted 917 B and C. there was no debate about the applicability of that guidance or the test of deliberate. The local authorities case was the PSED did not apply. That's page 97, paragraph 24. And in that context, Lord Justice Wilson made the comments he did at page 100, paragraph 36. So it doesn't help. The local authority is saying PSED is not relevant. No one was arguing about what the test was on deliberate.
I agree with that. I still say it helps, but I agree that's the ratio.
So I think now bid you a good day.
Well,
Unless you have any further questions.
I don't detect any. Thank you very much, Ms. Hutchings. Thank you very much, Ms. Davies. Thank you very much for the help you will have received from those behind you who, of course, have had speaking roles below, if not here. You won't be surprised to know that we're going to reserve judgment. You will be supplied with it in the normal way for you to correct our English and typing, but not, of course, with a view to re-arguing the case. We'd be grateful if at that stage you would seek to agree an order dealing with consequential matters. If there are points on which you can't agree, can we please have brief written submissions, and we would expect to deal with the points in the order that we make. Finally, though I know you will be very well aware of this, I ought to remind you all of the importance attached to the embargo. If you think of anybody we don't already know about who you consider ought to receive a copy of the draft judgment, you obviously need to come back to us for permission to achieve that. But thank you all very much.
All rise if able.